right, welcome to Ozarks Live. As you saw, the Pope made his arrival into the U.S., so our show today is going to be a little condensed, and tomorrow we're going to have to push the show back to 4 p.m. That's just for one day only. Now, joining us now, Will Worsham is here.
Hi,
Speaking
Will.
Legal. Good
Howdy.
to see you, Will.
How you doing?
Good to see you, too.
All right, we're going to zoom into the question right away. Okay, here it is. Now, I've heard Greene County is now a no-refusal DWI county. What does that mean?
Okay, yeah. Greene County is following along with some other counties that have done this in creating a no-refusal scenario for people that get pulled over for driving while intoxicated. And what that means, I've got to back up a little bit.
Okay.
So if you get pulled over for driving while intoxicated, or you can't get pulled over for that, but if you get pulled over and the officer thinks that maybe you're driving while intoxicated, they want to do some tests. There's a normal field sobriety test, but ultimately what they're going to want to do is take a sample of your breath. They're going to want to measure the blood alcohol content.
Right.
And the legal limit is 0.08, and there's a number of different ways that we can measure that, but the normal way is you take a breath test,
Right.
and you blow into a breath test. Well, Missouri has, as do all the other states, what's called an implied consent law. That says if you drive on our roads, you are giving us consent to sample your breath or your blood to determine what your alcohol content is. That's kind of the trade-off. You get to drive on the roads, we get to make sure that you're a sober driver.
Okay.
But we have some constitutional protections, and so you have the right to say, you know what, I'm not going to do that. I'm going to revoke my consent.
Okay.
And so you can refuse to give a breath sample, and then they can't take your breath because you said no. So
but there are other consequences.
Obviously, these laws have been developing over time, and this was kind of the new little wrinkle in all this. There's another body of law that says law enforcement officers can seize evidence if they believe they need it to preserve it for a later prosecution or later case.
Okay.
But they can't do that without a warrant unless there are what are called exigent circumstances. That means there's a real inherent need that they've got to do that right now, or else the evidence is going to be destroyed or some life or limb is going to be harmed. That's exigent circumstances.
Right.
Now, we have a case that said that doesn't apply to blood samples because we had some police officers in a scenario where someone refused to give a breath sample. They said, well, I need to seize your blood, and I have exigent circumstances because your body is processing the alcohol out of your blood and your blood alcohol content is going down. So I have a need to take your blood sample right now to preserve that evidence. Supreme Court said, no, that's not good enough. That leads us to where we are today.
Okay.
So we still have the ability of law enforcement officers to seize evidence if they have a warrant. Now, technology has now caught up to the point to where if we have an on-call judge and an on-call prosecutor, which we now have in place in Greene County now, that a police officer, if they were to pull someone over for DWI, say, I want you to give us a breath test so we can test the alcohol content of your blood, you say no, they say, I'm going to apply for a search warrant. And they fill out a form that gives the judge all the facts. They give it to the prosecutor signs off on it, submits it to the judge. This all happens electronically via fax, phone, and email now. The judge reviews it, signs a search warrant. The officer then has a search warrant to take your blood and then later preserve it for laboratory analysis to determine what the blood alcohol content is.
I want to ask you about taking the blood. Okay, so anyone can take your blood. He's an officer. Is he a phlebotomist? I mean, how does that work?
Right. Well, you need to have a phlebotomist, an official trained taker of blood, so to speak, to take the blood. So they'll call in a paramedic or a nurse or take you to a hospital to have that done.
Okay.
That's how that happens.
Some people don't like their blood taken. Some people are deathly afraid of something like it hurts. Oh, well, what about...
I don't like needles.
Yeah.
Yeah. And, you know, that's where this comes in. So if they take the blood sample, then fine. But the issue comes, and I've had this come up in my office a couple times, we've yet to get it litigated. This is a very emerging area of law, is what happens if a police officer says, essentially, if you don't give me a breath sample, I'm going to get a warrant, and we're going to take your blood by force if necessary, because that's what the warrant allows them to do. We're going to stick a needle in your arm.
Though,
well, and that's going to be the issue. If you then later say, well, listen, I don't want that to happen to me. I don't want to get stuck with this needle. I'll go ahead and take the breath test.
Right.
Is that consent then voluntary, or is now the consent obtained under duress, i.e. threat of physical violence, essentially?
Yeah.
We've yet to litigate that question, but that's an outstanding question that's going to come up, and I think it's an interesting one.
It is
There's
interesting.
more to hear on this, right?
Yes. Yeah, absolutely.
Rights.
Well,
Personal
thank you
rights.
very much.
Thank you, Will.
You bet.
All right, if you have a legal question for Will, you can email him at wworsham@color10.com, and, of course, he will answer your question on the show. Thanks again.
You're welcome.
All right, we'll be right back after this. Don't go away.